Welcome to everyone. It's great to see so many folks here on what is an astoundingly beautiful day for Hanover. So I'm Herschel Nacklis from the Rockefeller Center and the Department of Government here, and we're all extremely fortunate to have with us today Shep Melnick. He's the Tip O'Neill Chair in American Politics at Boston College. In addition to the book about which he'll speak today, he's the author of two other phenomenal and award-winning books that I highly recommend to everyone. He's the former president of the New England Political Science Association. He's the co-convener of the Program on Constitutional Government, and he is, this should be especially important for all of us, a former New Hampshire state legislator and a son of New Hampshire. So I should say just sort of one additional thing here, which is Shep's work and approach to thinking through really tough problems of American politics are unique and extraordinarily influential in political science. The way he thinks about the regulatory state, the way he thinks about law and courts have influenced literally generations of scholars at this point. The number of graduate students and junior faculty who have been told, just write this dissertation or this article or this book as Shep Melnick would, number in the hundreds. We all try to do this. We all inevitably fail. But lucky for you, you have the genuine article here today to explain Title IX, how we got the policy we have, and what its implications are for American politics and the regulatory state moving forward. So please join me in welcoming Shep to Dartmouth.
Thanks, Herschel. I'm not sure that's true about the graduate students, but I'll take the compliment. I also want to thank Joanne Needham, wherever she is, for shepherding me around and making it very easy. And it's good to be back home in Grafton County, even though it's the southern part of Grafton County. I'm from Littleton, so this does seem like the South Country to me. So let me start with a paradox when I talk about Title IX in my book. On the one hand, few federal laws have been so successful in meeting their original objective than Title IX. Title IX was enacted as a little-noted provision in 1972 Omnibus Education Act. It prohibits educational institutions that receive federal funding from discriminating on the basis of sex. As the doors of educational opportunity swung open for women, women rushed through. In 1972, 58% of college students were male and only 42% female. Today, that's reversed, about 47% female, 43% male. In 1970, men received 8 times as many Ph.D.s as women. Today, women earn more Ph.D.s than men. Once all but shut out of law school and med school and dental school, now women have reached parity in most of those areas. So even when I was in college, the opportunities for women were much, much reduced. This also happens at the elementary and secondary school level. Girls get better grades than guys. They have more extracurricular activities. They take more AP courses. They have higher educational aspirations. So I hate to say it, but guys are kind of losing out to women in virtually every part of the educational process. Thomas DePreet and Claudia Buckman wrote a book called The Rise of Women, and they say women have not merely gained educational equity with men. On many fronts, they have surpassed men by a large and growing margin. Now, despite this remarkable success, Title IX is now more controversial than ever. For years, we tended to equate Title IX with athletics. And for a long time, that was by far the most controversial part of Title IX. In 2011, the Obama administration issued controversial new rules on sexual harassment and sexual assault. In 2014, they added to those and started a number of highly publicized investigations of schools throughout the country. Virtually every school has been subject to it in one way or the other. I know that's true of Dartmouth. I know it's true of my school, Boston College. Then in 2016, the Obama administration's Department of Education issued a Dear Colleague letter, that's the term I'll be using, but a letter explaining what regulatory requirements OCR, Office of Civil Rights, had come up with, a new letter on the rights of transgender students. That really set off the so-called bathroom wars in North Carolina. And I'll just say that on the way up here, I was listening to the radio, and I think I heard about the next frontier in Title IX regulation, which is dress codes, which are already starting to become controversial. These initiatives of the Obama administration received harsh criticism, and not just from conservatives. The 2016 Republican platform charged that the original purpose of Title IX had been perverted, quote, by bureaucrats and the current president of the United States to impose a social and cultural revolution upon the American public. But they were joined by civil libertarians, bar associations, groups of university professors, and many prominent legal scholars, including four very well, four esteemed women law professors at Harvard, who are worried about due process and free speech implications of these regulations. The Trump administration quickly revoked the Dear Colleague letter on transgender rights, and a few months later, Secretary of Education DeVos withdrew the sexual harassment guidelines. She promised to initiate a full rulemaking process on the subject, saying the era of rule by letter is over. However, while that happened about 8 months ago, there's been no action on rulemaking. They haven't even started it, and that's going to take not just months, but quite a few years. Meanwhile, the federal courts, in 2 circuits, said that Title IX doesn't just allow the transgender regulations that OCR had initially announced, but that Title IX requires them. So that is going to be played out in the courts. In short, this controversy that began in 2011 is going to be with us for a very long time. And as in most things in American politics, it's going to be a while before we see a final resolution, if we ever do see a final resolution. Now, what I want to argue here, and this is really kind of the central argument of my book, The Transformation of Title IX, is that the key to understanding this paradox of success on the one hand and controversy on the other is to see how distant current regulations and current controversies are from the original conventional understanding of Title IX's purpose. The initial purpose was to eliminate institutional barriers to educational opportunity by women. In the course of the implementation of the Act, we moved first from the classroom to the playing field with athletics, and then we moved from the playing field to the bedroom and the bathroom. Why was this? It's because the purpose of education, of regulation changed, so that now the purpose is trying to uproot a wide variety of stereotypes about gender. How we think about gender, not just students, not just administrators and faculty, but the public at large, how we think about gender roles, gender and sexuality in general. So that's my claim, that we've seen this fundamental shift into a much more controversial, much more complicated area of endeavor. And I want to illustrate this by looking first at athletics, and then at sexual harassment, and then very briefly at the transgender issue. But before I get to that, I really have to lay out a couple of things about the structure of Title IX. This gets a little bit into administrative law areas, but I'll try not to make it too complicated. Tracing the evolution of Title IX rules is difficult because of the very peculiar way in which rules are made and enforced. Title IX authorizes the Office of Civil Rights in the Department of Education to issue regulations to carry out the purposes of Title IX. That's a pretty standard thing for administrative agencies and for regulation. Like all regulations, they are governed by the Administrative Procedure Act that lays out something called notice and comment rulemaking. It's pretty much what it sounds like. You have to say, give a notice that you're thinking about a regulation, accept comments, respond to the comments, and make a final rule. That's fairly standard. Title IX goes beyond that and said all of these regulations need to be signed by the President of the United States. Why? Because the understanding was that these were going to be particularly controversial regulations, and they wanted political accountability. Remarkably, the last time the Office for Civil Rights followed these procedures for a major Title IX regulation was 1975. So ever since then, we've been doing something quite different. So instead of using regulations, we have issued, OCR has issued unilateral clarifications, interpretations in the famous Dear Colleague letters. Some people in academia, including me, do not consider regulators in Washington to be our colleagues, but evidently they think they are our colleagues. Now, these guidelines wouldn't have much punch if there wasn't some enforcement behind it. Where does that come from? Well, it's come from the courts, but again, in a very unusual way. Title IX says nothing explicitly about judicial enforcement. As a matter of fact, it says that the most important enforcement tool is the funding cutoff, the only one that's mentioned. But the funding cutoff, here's another interesting factoid. The number of times an institution has lost federal funds for violation of Title IX is 0. They have never done it. Why? It's administratively cumbersome, and politically it's dangerous. So enforcement has taken a much different route because the courts have identified what they call an implied private right of action in Title IX. What that means is they read into the act the right of private citizens to bring a suit for violation of Title IX to seek either an injunction or private damages. So if Dartmouth does not provide equal education, equal athletic opportunity for a student, they can sue not only to increase the number of slots for female athletes, but also money damages for any harm that they claim was done to them. So to the extent that the courts in these enforcement actions are willing to defer to Dear Colleague letters and interpretations and clarifications, they in fact become binding law. And if you want, we can talk more about that in the question and answer. As a result, Title IX regulation has proceeded in a way that I call institutional leapfrogging. You know, what I mean by this is the agency will take one small step, the courts will accept that and take another step further, and then the agency will say, well, we're going to accept what the court do, but go down one further, and you get this very long cycle of incremental change that each one individually does not look very big, but when you look at the full expanse, it's quite extensive. One reason my book is 300 pages long is I try to do the archaeology to trace through this, and it's not a very easy task to do. Now, one of the consequences of this form of policymaking is that each one of these institutions claims it is doing nothing new. Because if you're doing something new, you'd have to use rulemaking. So you have to say, well, there's nothing new here, you know, as I say in the police procedurals, you know, look someplace else, go away, nothing to see here. So in 2011, 2014, when Office of Civil Rights issued its new regulations on sexual harassment, they said that there was nothing new here, just a clarification of previous regulations. The White House said this was groundbreaking. When the Office of Civil Rights issued its regulations on transgender rights, say basically that you had to allocate access to sex-segregated facilities on the basis of gender identity, not biological sex. That struck people as pretty innovative. You might like it, you might not, but it's pretty innovative. OCR said, nothing new here, just established policy. So what is the consequence of this? Well, you are inhibited from either explaining what is new, more importantly, considering alternatives, considering cost, trying to anticipate consequences, thinking about opportunity costs, all of the things that we kind of expect people to do when they're trying to make sensible public policy. But all that, much to my surprise when I started studying this, is lacking. So let me kind of tell how the story played out first in athletics. And the point I want to make here is how we went from concerned about institutional barriers to equal educational opportunities to this trying to uproot a wide variety of stereotypes. Now, you might wonder why it is that Title IX pays so much attention to sports. Sports, at best, in educational institutions, is a useful extracurricular activity. At worst, and I think a lot of times it is at the worst, it is a deeply corrupting influence. So why so much attention to athletics? And the answer is that we segregate on the basis of sex in athletics. We do that because we do not think it would be fair to say to a woman athlete, you can't jump as high, as run as fast as the guys, therefore you don't make the team. Title IX, by the way, was based on a similar prohibition of discrimination on the basis of race. But it's important to see that race and sex are not always equivalent. We don't allow racial, separate but equal in sports involving race, but we do on the basis of sex. So we got to figure out, what does equal mean? There were two, in 1975, I put over one too many page here. In 1975, was then called the Department of Health, Education, and Welfare issued the first set of regulations, the only set of regulations, and they said the opportunities that schools offer to men and women in sports have to reflect the relative interest and abilities of male and female athletes. Relative interest and ability. That's pretty vague, and no one knew quite what that meant. And it really took about 20 years before we started getting any serious enforcement. And in that time, we made two crucial choices in regulatory policy. One of them was very controversial. One, I think, was given virtually no attention. What was controversial? One version of what equity means is that you give, if women are less interested in sports than men, they get fewer varsity slots. That the number of varsity slots should be proportional to their relative interest. The other version was often called the parity view, which is that the proportion of male and female slots should reflect the male and female proportion in the student body as a whole, regardless of the relative interests. The courts and the Office of Civil Rights adopted the second view, the parity view, which means that if a school is, say, 55% female, the varsity slot should be 55% female. Now, most schools don't do that, but that is the goal at which they are supposed to aim. The clearest and most important explanation of this parity standard came in the First Circuit's 1996 decision in Brown University versus Cohen, by far the most important decision on athletics. Women's level of interest in competitive sports, the court asserted, quote, reflects women's historical lack of opportunity to participate in sports. To provide fewer athletic participation opportunities for women than for men, based on the premise that women are less interested in sports, is to ignore the fact that Title IX was enacted in order to remedy discrimination that results from stereotyped notions of women's interest and ability. You have to correct stereotyped images of women's ability and interest, not just among the existing students, but among students who might apply and among the public as a whole. What this meant was that schools have an affirmative obligation not only to create more women's teams, but to recruit more women athletes to fill them, and to offer the equal number of scholarships as they do to men. So this was the first appearance of this big emphasis on eliminating stereotypes. The line that became repeated over and over in this area by courts and advocates alike came from the movie Field of Dreams. You know, the people my age here remember Field of Dreams, some of the younger ones might not. But the big line was, build it and they will come. You build the teams, you create the opportunities, you recruit the students, and people will appear to fill those positions. I said this was the controversial part, and this was really revolved around the question, to what extent are different male and female interests in athletics in part natural or entirely socially constructed? So this is the type of thing that academics love to argue about, and the view that was adopted was that they are entirely socially constructed. Now, the other choice that was made that I think has received far too little attention is, what numbers are you going to use? one of the advantages of being someone who studies regulation, you want to be concerned about how do regulators make their choice manageable. And the choice that regulators made, with very little explanation, is we're going to focus on varsity slots. Varsity slots, not intramural, not fitness, not recreation, not club, not even JV, but varsity slots. Now, in a school like Dartmouth, in the Ivy Leagues, and often in many small liberal arts schools, the number of athletes is fairly large. But at large places like University of Texas, as Russ will attest, how many students there were? 25,000, something like that?
Closer to 50,000.
Wow. Yeah. And there were 300 female varsity athletes and 300 male varsity athletes out of 50,000. So what we're doing is we're focusing on this really tiny part. And I will point out that these slots are expensive. They're expensive because of the cost of running these very highly competitive teams. And at selective schools, they're very expensive with the coin of the realm, which is admission slots. So this is a big commitment of resources. Why did we focus on this narrow slice? Well, I'll give you a couple of reasons. One is administrative convenience. That's what we can count. And if you have to get involved with the job of how do you compare a yoga class with a football team? You know, so these comparisons are really hard. That's one reason. Number two reason, the NCAA. The NCAA tried to kill Title IX as it applied to sports in the 1970s. It failed. It then figured, you can't beat them, take them over. So they said, we're going to sponsor women's competitive sports. They forced out of business the female-led organization that, in my view, had a much healthier understanding of varsity sports. And they basically said, we are going to sponsor all kinds of varsity championships. And we will we'll cross-subsidize by all of the money that we're making in football and basketball. There was a part of the deal there, implicit, but I think powerful, which is we will support women's varsity sports if you don't touch football and basketball, men's basketball. So that was kind of the deal that many supporters of women's sports made. Now, if you try to understand the position of women's advocacy groups, one group I think is easy to understand is a group called the Women's Sports Foundation, started by Billie Jean King. They are in the job of promoting professional women's sports. They make no bones about it. And they want college sports to be a pipeline for Olympic and for professional sports. So their interest is congruent with the NCAA's. Other women's advocacy groups, and I list here, head of the list, the Women's Legal Center, did it, I think, for a different reason. And that was because they consider women's sports to be the best way to change stereotypes about women's passivity, weakness, and lack of kind of aggressiveness. So they said, well, look at all of the role models that we have created, and certainly that is true. But the emphasis is not just on providing opportunities to people who are in college, but changing how people outside college think about gender differences. How do you do this? How do you kind of increase the number of varsity sports for women without cutting football and basketball? One thing you can do is cut minor men's teams like wrestling and swimming. But that got a fair amount of outcry, especially from Speaker of the House Denny Hassert, who, before he was in jail, he was a wrestling coach. I won't go into any detail on that. But the answer was extend the the athletic pie. Just spend more on it. Eleanor Schmiel, who was former president of the National Organization of Women, put it this way: dropping men's teams is a violation of the spirit and letter of Title IX. The purpose of saying you're not going to discriminate is not to limit opportunities of the other class. This should not be a zero-sum game. But of course it is a zero-sum game because budgets are limited. So the effect of Title IX, this, I think, tacit deal, just spend more on athletics. And not all athletics, varsity athletics. According to, I say, these many women's advocacy groups, the advantage of college sports is its visibility. If you want something that's going to change stereotypes, go for the most visible thing that colleges do. Let me just give one idea, indication of how this applies outside universities. In 2012, the Seventh Circuit required an Indiana high school to schedule more girls' basketball games on Friday and Saturday nights. It argued that relegating girls' games to non-prime time results, quote, in a loss of audience and fosters feelings of inferiority that oppress girls' interest in basketball. Quote, disparate scheduling creates a cyclical effect that stifles community support, prevents the development of a fan base, and discourages females from participating in a traditionally male-dominated sport. Title IX requires schools to counteract stereotypical notions of women's interest and ability by increasing the audience for girls' games, which means you really have to change how people outside the institution are thinking about these things. Now, the question I would like to raise, I think hasn't gotten raised enough, is this good for girls' and women's education? This is a question that gets lost in these debates. One person who thought it was not good was the president of Brown University, Vartan Gregorian, who fought tooth and nail and lost that First Circuit decision. He complained that by judicial fiat, women's sports had risen past all other priorities, including undergraduate scholarships, faculty salaries, and libraries. More money for athletic scholarships meant less money for talented musicians, mathematicians, and political scientists, most importantly. And remember that the people who are doing well in all of these areas are disproportionately female. According to an important study by William Bowen, who is the former president of Princeton, and his co-authors, they found that before Title IX took hold in the 1970s, female college athletes had similar college records to non-athletes. They performed equally well in college, and they went to graduate school even more frequently. The argument was that they're a bit more aggressive, willing to take risks. They went back and looked at, they had this amazing data set, what happened after Title IX took hold in the 1990s. What they found was that the female athletes had significantly worse high school records. Even in light of that, they underperformed in college, and they were less likely to go to grad school and enter a profession. Having devoted so much of their young lives to a single sport, many of them had not developed academic interest. As Bowen and his co-authors put it, the women athletes appear to have caught up with their male counterparts, a dubious distinction. And I say that throughout this process, no one asked the crucial question, is this good for women's education? So that I'll now turn to sexual harassment. This will be shorter. I'll start off by pointing out it took a quarter of a century before the Office for Civil Rights said anything about sexual harassment. Part of the reason for this is the peculiar nature of this issue. Sexual harassment differs from athletics in at least two ways. First, the central problem here is not what the school itself is doing, or at least directly. It is what is happening among students, in between student and faculty, and students and staff, outside official circles, and often in highly private settings. That means that what the responsibility of the school, when it was established, is to monitor and control behavior of thousands and thousands of people on campus. Second, it's not clear exactly why sexual harassment, even in its ugliest form, which is sexual assault, constitutes sexual discrimination. At first, many courts simply said, harassment might be bad, but it's not discriminatory. Eventually, judges ruled that harassment does constitute discrimination, but only if it's aimed at a particular member of a particular sex. So if a man harasses a woman, it is because of her sex. So you can say that fits the law. If a woman harasses a man, you can say it's because of his sex. If a gay man harasses another gay man, it's because of his sex. They wouldn't have done it if the person had been of a different sex. But this came up in several early court decisions. What about a bisexual harasser? They are literally indiscriminate, right? So, and the court said, not discrimination. If you're indiscriminate, you're not discriminating. Now, if this seems loony to you, it should seem loony to you. So Robert Bork, when he was on the DC Circuit, wrote a dissent in a case where he said, this basically can't be right. He said, this bizarre result shows that Congress didn't mean to cover sexual harassment. Had Congress been aiming at sexual harassment, it seems unlikely that a woman would be protected from unwelcome heterosexual or lesbian advance, but left unprotected when a bisexual attacks. So the court, but eventually the court said, never mind. We're just going to say that sexual harassment is bad, and we don't really care who does it and who it's aimed at. Now, I mean, that's really fine with me, but what it meant was that they never explained the legal argument. And people read into the legal argument much different remedies. So we ended up having a big argument about the proper remedies because it was never clear why this was discriminatory. Now, when the courts did start to apply Title IX in these implied private rights of action, they did what they usually do, which they tried to say, where else have we seen this process working out? And the best place to look was Title VII of the Civil Rights of 1964 that bans discrimination in employment. And from 1980 on, they developed employment law on sexual harassment. So they looked at that, but they said, we recognize that schools and employers are different, especially if you're dealing with elementary and secondary education. They're less mature. They can engage in a lot of things one would never allow on the workplace. If you're dealing with colleges, colleges are much less structured than jobs. And when the seniors go out in the job market, you realize you're going to have to put up with much more structure on the jobs than you were used to. Employers tend not to have dorms where who knows what goes on in them. So there were differences, but they applied the same thinking, which was from tort law, that sexual harassment is a tort, a wrong done to someone. And the way to make sure employers do something about this is to make them liable for these torts in certain circumstances. So it was liability law, and it really was based on two assumptions that were later got questioned. Assumption number one, most harassment is the work of a few bad apples. And what we really want to do is get rid of these bad apples, either by disciplining them or by eliminating them. And in employment, kind of easy. You just throw them out. You fire them. The other assumption was that if you create the right incentives through tort law, you're going to create the incentives for the institution to make major changes. So the idea was that if you want to avoid liability, you set up procedures for issuing complaints. You show that any complaint you've dealt with quickly and effectively. And you make effort to try to inform people about what is improper behavior. And if you do those things, you're not going to be liable for damages. If you fail to do them, you could lose really big in court. Federal courts argued about the right level of liability for many years. Eventually, the Office for Civil Rights in 1997 issued a set of rules basically based on the most demanding court rulings, a relatively high level of liability. Basically, strict liability for harassment by teachers and a negligence standard for peer harassment. If there are any lawyers in the audience, you know the difference between strict liability and negligence. In 1998 to 1999, though, only 2 years after Office of Civil Rights issued these rules, the Supreme Court issued two important decisions, and they took a very narrow reading of schools' responsibility for harassment. Justice O'Connor's opinion said that to be liable, you have to show actual knowledge. Someone in a position of power in the school had to have actual knowledge of this harassment and react with indifference, deliberate indifference. That's a pretty narrow liability. Moreover, the court said that awards for damages were made only for harassment that is so severe, pervasive, and objectively offensive that effectively bars the victim's access to educational opportunity. And Justice O'Connor also said that judges should refrain from second-guessing the disciplinary decisions made by school administrators. So basically, you say, we think that there's some liability here, but you better courts and agencies better back off. The day before George W. Bush's inauguration, the Clinton administration issued new rules. These are the kind of classic midnight regulations. As a matter of fact, they didn't even get them to the Federal Register in time, so they had an appendix to the Federal Register notice. And they said, we consider these far too lenient, and we are going to go well beyond that. In bland legalistic language that belied the major step it was taking, the agency explained it would no longer describe a school's compliance in terms of liability law. Instead of explaining what schools can do to escape liability, OCR spelled out in detail what steps schools must take to prevent, eliminate, and remedy sexual harassment. Let me just prevent, in a large school, that's pretty hard to do, eliminate and remedy all forms of sexual harassment. Now, this is a pretty clever legal argument, but it had one big problem. You can say that this is administratively binding. How are you going to enforce it? You're not going to cut off federal funding. You can't rely on the courts. So what do? And for 10 years, those regulations remained in limbo. The Bush administration thought they had been issued illegally, but figured, what the heck, no one's going to enforce them. When the Obama administration came in, after a couple of years, they decided that they wanted not only build upon that framework of sexual harassment regulations, but start aggressively enforcing them. How do they do this? Well, they actually came up with a very clever strategy, which was, in the past, all of when Office of Civil Rights got a complaint from an individual, it would investigate that individual complaint. It would, if it reached a settlement with the school, it would do so only at announce it only at the end. It would not announce an investigation at the beginning, only at the end. So OCR made two big changes. The first, they said, when we get a complaint from a student, we're going to investigate the entire institution. We're going to look at everything. We're going to require records from years back. We're going to spend months and even years investigating this institution, and we are going to announce the investigation at the very beginning. Why are we going to do that? We want to put pressure on schools to settle. We want to do some damage to their reputation if this drags on. And they began investigating many of the most prestigious schools in the country. For that reason, they want to basically, if you think you're prestigious, see what happens to your reputation after we investigate you for several years. And usually those agreements would culminate in binding legal agreements that remain in place no matter what OCR changes in its regulations. The second part of the strategy of OCR, and again, I think this was very clever, they were intent upon building up very large internal Title IX compliance organizations with many responsibilities. And those organizations would be there long after OCR left. And they would have an interest in their own self-preservation and expansion. Now, one of the things that was interesting about these new sets of regulations was that they really had a coherence to them that was explained by a couple of the assistant administrators of OCR. One, Ruslan Ali, who's assistant secretary in the first term of the Obama administration, said this is a new paradigm that we're relying upon here. And the new paradigm really reflected a previous critique of tort-based liability that had been enunciated most clearly by Catherine McKinnon, the famous feminist legal scholar. And her argument was basically that the tort approach treated something as individual that was systemic. The act of a few bad apples who need to be thrown out. Her view was this was part of a broad culture. And the schools would not do anything about this until they were absolutely forced to do it. that this was institutional and systemic, not individualistic. And this was reflected in two ways in the new regulations. Number one, the understanding was that you had to change the culture. You had to change the rape culture. I give you a number of quotes about this, but this was pervaded the rhetoric both of the Office of Civil Rights and the White House in announcing these programs. You can't simply do this through punishing a few individuals. You have to engage in wholesale cultural change. So that was change number one. Number two, you can't count on educational institutions to do this just by manipulating a few incentives. You had to force them to make huge changes in their institution. And that's why you needed to build this internal compliance organization. Now, many of the critiques of the sexual harassment regulations have focused on due process and freedom of speech. And there's a lot of writing on this. I think there's some excellent articles. I particularly recommend Emily Yoffe's pieces in the Atlantic, which are really extremely good pieces of journalism, and Laura Kipnis's book on her experience at the Northwestern University being investigated for things that she wrote in the Chronicle of Higher Education, usually not thought of as a kind of a hotbed of inflammatory rhetoric. So I think these are serious matters, and some of the students we talked about this before, but I want to focus on something different. And that is the, I think, frequently overlooked way in which Title IX offices are engaged in extremely extensive training of everyone in the university. I assume all the students have gone through this training several times. I'm sure the faculty have. I was told that the Title IX coordinator at Dartmouth was invited to this event, but he or she couldn't come because she's giving a training. So I will use that as evidence that a lot of training goes on. So what is this training? It's training basically on proper relations, what's a healthy relationship, what's an unhealthy relationship. For example, Yale tells its students, hold out for enthusiasm. In general, it's easy to tell if someone is enthusiastic about an encounter with you. I'm not sure that's true, but maybe. The University of Georgia advises students, quote, if you are not accustomed to communicating with your partner about sex and sexual activity, the first few times may feel awkward, but practice makes perfect. Be creative and spontaneous. Don't give up. Unfortunately, the Office of Civil Rights guidelines say repeated rejected overtures themselves constitute sexual harassment. So you'd better give up. So if students are getting kind of conflicting signals here, I can understand why. But the point I want to make here is the role of these offices in teaching us about matters relating to sexuality. And I think the best way I can do this in short term is to quote from a really interesting article in the California Law Review by two Harvard law professors, Jacob Gerson and Jeannie Suk. And they note that the college, what they call the college sex bureaucrats who run these federally mandated programs, are not simply training students about the rule of rape, sexual assault, and sexual harassment. Sexual violence education and prevention is rapidly morphing into sexual instruction reminiscent of guidance provided by sexual therapists like Dr. Ruth. So we have extensive sex education performed by Title IX offices. That's what you need to do if you want to change the culture, right? You got to change how people think about sexual relations. Now, knowing what goes on in many of these college training programs is hard, number one, because they vary greatly from one school to another, and second, because many schools keep this stuff private. I'm not sure why, but they keep it private. But let me give you a flavor, and this comes, I'm going to make fun of Princeton. I'm sure no one here will mind that. Consider, for example, Princeton's 2017 description of a new position, quote, interpersonal violence clinician and men's engagement manager. The person will develop challenging programs challenging gender stereotypes and those belief systems and social constructs that contribute to violence. Candidates for the position must have knowledge about the challenges and privileges of male identity formation and expertise in social justice issues. This language is quite common in ads for people to serve in these offices. if any of you are in political theory, I think this is an opportunity because you, I would think, are the experts in social justice. So Russ can place you in these positions. Now, the Trump administration has withdrawn these guidelines, but most colleges have made it clear that until they know what's going to take their place, they're not going to change. And of course, these offices are committed to their mission. They are relatively large, they're well funded, and they're going to continue until either the Trump administration provides a reasonable alternative, and I'm not convinced they will, or until they're forced by external pressure. As political scientists, we know that retrenchment's always hard. So finally, this will be pretty short, the transgender issue. Regulation of athletics and sexual harassment took years to develop. The transgender issue appeared incredibly quickly. For many years, everyone thought that Title IX didn't cover transgender issues. That included President Obama, who said, this will take new legislation. When it was clear that new legislation was not going to pass, and under great pressure, political pressure, the Obama administration changed its position and said that the transgender issues were could be regulated under Title IX. I'm going to skip some of this in purpose of time. So when it came to employment, the issue, I think, there was an arguable legal position which said if you refuse to hire someone or if you fire someone because they don't dress or appear like the gender they were born, then you're really discriminating against a man for dressing like a woman and discriminating a woman for dressing like a man. So there's some argument there that that's the type of sex discrimination. But the issue that arose in education under Title IX was different. That was access to sex-segregated facilities. And the law provides sex-segregated facilities. So the question is, who gets to go to what bathroom? Who gets to be on what athletic team? Who gets to go in which dorm? And the Office of Civil Rights said, you must make that distinction only on the basis of gender identity. You must respect the gender identity of each student, even if that creates discomfort among others, like a roommate or someone in the shower. So it was a fairly absolute position. The only wiggle room was on athletics. Now, the problem with that legal argument is that when you think that the term gender identity was created to distinguish it from sex, that one's gender identity is different from one's biological sex. So the argument had to be that when Congress and regulators said sex, they didn't mean sex, they meant the other thing, which had been distinguished from sex. So this is kind of an odd argument. That regulation was struck down by a district court in Texas, never went into effect, withdrawn by the Trump administration. But a number of circuit courts have said that that is exactly what Title IX requires. Not only allows it, but requires it. So we're going to have a battle over that for some time to come. Shortly after she left the Office for Civil Rights, Assistant Secretary Catherine Lehman told an interviewer, the bathroom question never was just about bathrooms. It was about who that child is at school and how that child is perceived and seen. So any stigma that might be attributed to, attached to a transgender student has to be changed by changing our perceptions. And that's really what this is about, kind of changing our perceptions of what gender means. Now, I don't think any of this about transgender rights is going to have a big effect on schools. There aren't a lot of transgender students. I would hope that schools can deal on an individual and compassionate basis with these students. But it does illustrate the importance that we have put on changing people's stereotypes about gender, about sexuality, and about gender roles, and how that has underlay all of these major changes in Title IX regulation. Some of these regulations are becoming at war with one another. So, for example, under Title IX sexual harassment rules, a bad joke can be sexual harassment. An innuendo can be sexual harassment. So all these subtle things can be sexual harassment that are sufficient enough to hurt someone's education. But on the other hand, if a person with male genitalia is walking around in a women's locker room, that should be considered completely non-threatening. That strikes me as a little bit out of proportion. The other thing, and actually I'll close with this because this really bothers me. One of the worst instances of sexual abuse that we have ever seen on a college campus took place at Michigan State University. We know that all kinds of people turn their back on that. The president of the university, the athletic director, the parents. There's a story in the Times of parents literally turning their head, being in the same room with that odious doctor while some of this abuse took place. Why did that happen? I think it happened above all because there was so much emphasis upon having winning teams, being a gymnast, a world-class gymnast. They put, those girls and women put up with so much you would not believe it. Why do we allow this? Because competitive sports has become so crucial to some people in college and to the college as a whole. So if you want to find a place in which these policies are coming in contact with each other and conflicting with each other, I think that is the first place to look. So let me just close to say that providing equal opportunity to women, I think, should be very high priority. But in thinking about Title IX, we should start from the question, is this good for women's education? And I think in a number of these instances, because of the way in which policy was made, the answer to that question is no. So I look forward to your questions, and sorry I've gone a little bit over.
And we do have a mic, so please just wait for me to hand it to you. I will be running around.
Ooh.
I'm good.
Hi, thank you so much for speaking with us. So a number of issues have obviously arisen from Obama-era OCR regulation, such as like suggestions for how sexual misconduct cases should be handled, which with like single investigator models and lack of cross-examination sort of threatened due process, and also sort of the cottage industry that's sort of risen around like sexual violence prevention programs that are marketed to colleges at high rates without any evidence. So that being said, I'm just wondering, like, do you know how these regulations were actually, like, how they were formed? Like, what was the process, if not with any stakeholder involvement?
Sure. Do I have any inside knowledge? And the answer is no, I have no inside knowledge for a reason that really bothers me, which is every time I asked to interview people in OCR, they said no. I tried in Washington. I saw we don't allow interviews. I tried to do an end run to the regional offices, actually set up a couple of interviews. They said, let's just check with Washington. And I said, whoops, can't do it. So it's a very closed system. What kind of public participation was there? Very, very little. I mean, the wonderful thing about notice and comment rulemaking, as long as it can take, is you have to have public participation. You have to have hearings. You have to accept comments. You have to respond to the comments. So you can see more of the internal process. When you have Dear Colleague letter, you have none of that. And one of the odd things about the Dear Colleague letter is they say, if you have any comments on these rules, tell us, after they've already announced them. So what good's that going to do? And what I fear most is that there was not very much information gathering, considering of consequences, and I think that's a very serious problem. And what we're seeing now, I said this to some of the students before, we're now seeing some of the, working out some of these problems, more experimentation, but after we've already set up many of these programs. So it's kind of, we put the cart before the horse.
So sorry. So I need more time to formulate this.
Okay. Yeah, I've had a long time to formulate my thoughts out.
Hi, so I have two questions. So my first question is, due to the fact that the women to men population ratio is about 50-50, almost, what do you attribute the differences in school performance in light of this fact, and that women have increased educational opportunities now? And then my second question is, although measures of sexual assault reports are not actually great measures of sexual assault prevalence, is there any research that you know about that connects lower levels of sexual assault with higher levels of student performance?
Let me go to the first one. I'm not sure how I'm going to answer the second one, but the first one, we do know that superior performance in schools starts at a very early age for girls. Partly they can sit still better. Partly they develop earlier. And I think what's happening is once opportunities were open to women, these advantages of early development and be able to sit still and listen to directions really started to have cumulative effect. So I said that's kind of the, you should note that I'm really attributing this to the natural superiority of women. But guys eventually catch up, but I think it's gotten harder for them to catch up. Now, I'm sure there are a lot of other reasons as well, but that strikes me as one of the most important. When you have equality of opportunity, you're going to get you're going to get unequal results. And I think that has proved to be true for women. On academic performance and rates of sexual assault, I really don't know. And what I would say is one of the most important things we don't know very much about is both the prevalence of various forms of sexual assault and what are effective prevention techniques. That's another thing I wish that we had had more information on before we started the process. We are starting to get better information through the surveys that are done in a variety of colleges. But they have some difficulties. One of the difficulties has been very inconsistent definitions of various forms of harassment and assault. The other is often very low response rates. So it tends to be probably get a skewed sample because people who have experienced various forms of assault and harassment are much more likely to respond than people who haven't. So it's important to have randomized samples, which we generally don't have, and to have consistent. Let me just say one thing. Here's one of the surveys that had the biggest response and therefore was more reliable was Harvard's. And they found a pretty high level of various forms of sexual assault. The bizarre thing was that the students were asked, did you report this? And the vast majority did not report it, even after the publicity and making it easier to report. And they were asked why. And I won't go into the details, but when you looked at the most serious types of behavior that are violations of criminal law, about 50% of the students said they didn't report it because they didn't think it was serious enough. And I'm thinking, that's not serious enough. You know, others said they didn't want to get the other person in trouble. And some said, but a smaller number said, we think it'd be too much of an ordeal to go through. So that one I understand. The others, I realize how much of this phenomenon is really, I'm not grasping.
One of the things I thought was really interesting was when you talked about the high school women's basketball team that had the court injunction to play on Fridays and Saturdays. I thought that was like a pretty high level of court intervention, whereas like in the NCAA, male sports teams tend to get way more money. And I was curious why you think that. I mean, yeah, okay, they're the same number of varsity spots for men and women, but is it like based on the NCAA or based on the idea that some sports inherently need more money than others, that male sports tend to get so much more funding?
Yeah, this is a very big issue, and I say the two outliers. I mean, they're generally men's teams and women's teams get similar funding with two big exceptions, and they're obviously the money raisers, right? So you spend a lot on basketball coaches above all. You don't have that many players, but you have a lot of coaches, and you have expensive arenas. So the argument basically there is it's such big money makers that you can invest money in it. But, I think there's a big but here. A lot of schools claim they make money on athletics, but the number of colleges that make money on athletics is probably around 10. And you only get up to 10 if you don't count the capital costs. So that's pretty bad accounting. The amount that is being spent on men's basketball and football is going up and up and up. It's unsustainable. As George Schultz said, anything that can't go on like this forever won't. But to give an indication of how things have gone in football, University of Michigan has obviously a multi-million-dollar coach. You knew that. To lure him away from the NFL, you have to give a lot of money. But you probably didn't know that they have 6 assistant coaches that make more than $1 million. 6 assistant coaches. And in almost every state, the football coach earns more than anyone else in state government. In my school, Boston College, the football coach makes even more than the hockey coach, even though he's had a lot worse couple of years.
I come from this from a different perspective. I graduated in college in '64 as a physical education major in New York. And so I look at how it's affected women's performance in athletics in the K through 12 arena. And when we were in college, you sort of had to prove you could be feminine and an athlete. That's gone by the boards now. The other thing is that when we played basketball, you played half court. You were either offense or defense. And then we had this idiot thing where we were roving. 2 people could go back and forth. Now, who made up those rules? Men, not women, because we were playing field hockey with 40-minute halves where you couldn't get a substitute. And if you substituted, you were out of the game. So why could you survive hockey and not survive playing basketball full court? But the significance for me was I went into this because I wanted women to select something that they loved, that they would do as healthy activity for the rest of their lives. And when we were growing up, being a woman athlete was not something that a lot of people did. And so that's a really important thing. Many, many, many more girls and women are participating. They run, they ski, they do everything. And it's a very different approach to their health than it was when it was not seen as something you did as a female. So Title IX, in opening up those opportunities, also changed the attitude of young women.
Yeah, so those are really important points. I just add a couple of things. The first is that one of the things I really praise the Obama administration for doing is paying attention to elementary and secondary schools. Before the Obama administration, they got almost no attention. You know, this focus on varsity college sports was so profound. And that's where it's probably where the gaps are biggest. That's where probably the effects will be most important. I mean, we have an obesity crisis in this country. Sports are an important part of that. Another point I would make is when you talked about women athletic directors. And when, in 1972, about 90% of coaches of girls' teams were female. Today, I believe it's about 40%. 40%, is that about right? What happened was when schools decided we're going to recruit, we're going to give scholarships, we want winning teams. How do we get winning teams? We got to have men coaches. I won't go into some of the bad things that happened then, but a lot of bad things can happen. The other thing I see in the back of the audience my high school friend Mike Cryans. Now, Mike Cryans was when we ran cross country, he always won. And I was always at the back of the pack. But I like to think that I learned something from that, without being particularly competitive, that served me very well in life. So it's participation and not just doing it at the very highest level. Russ?
Thanks, Alexa. Shep, apart from the good and bad in Title IX and the way it's been interpreted and applied, what I'm struck by is just your account of politics and what politics is. And when we think of, democracy, in the ideal, you think of, the people, and the people voting for candidates like your classmate, and those candidates getting elected and going into office and passing laws that reflect, at the best, reflect, popular interests and popular ideas. That's making democracy work. But what yours is a story of regulators who have much more well-defined ideological convictions than normal people, and who get to indulge those convictions and apply them, through their positions in the Office of Civil Rights and the Department of Education. And then judges who further refine their ideas and even schedule, get involved in the scheduling of high school sports. This isn't legislation. This isn't democracy. This really is just ruled by some narrow group of people. And it strikes me that this radically inflates the power of the president, who gets to appoint judges and gets to appoint these other people. And what I'm wondering, listening to you, is where is Congress?
Yeah.
Why is Congress supine? Why is it silent? Why isn't it stepping in and saying, whoa, we want to clarify what Title IX should mean. We want to refine it and improve it and do a better job than we did in 1972 when we tossed this thing in without thinking about it. Why is Congress out of the action?
Right. So Congress definitely is out of the action. They have done nothing to clarify what Title IX requires in any of these areas since 1972. So clearly there has been non-benign neglect by Congress. Your question really raises the issue about what's these days called the administrative state. And I would say a couple of things. One thing, if you want kind of an example of how kind of lower level administrators and judges make policy in a non-visible form. I think sometimes even they don't understand what they were doing because they were doing this incremental growth. This is a great example. This is kind of the hazards of the administrative state. But when this term is often used, I gotta say particularly by conservatives, I think that they make this case study does not fit. Because this is not done simply by unelected administrators. Judges played as big a role. And most importantly, as the point Russ made, was that presidents have played a big role. Most of the expansion has happened under Democrats who have appointed people who agree with them, who are responsive to a political coalition, and those change. One of the difficulties of doing things through unilateral dear colleague letters, a new administration come in and revoke everything that's been done. So this is, it is a problem with low visibility politics, and it is above all a problem of congressional inaction, but it is not a case in which the administrative state is not under the control of elected officials, because above all, they are being controlled to some extent by the president, and it's not running wild without judicial oversight. If anything, there might have been too much judicial oversight. So it's a complicated picture in that way.
Sorry. Yeah, I have a great follow-up to that. I would push back, in fact, against the idea of this like over-powerful administrative state. Because to me, it seems like I really appreciate your criticisms of sort of the dear colleague letters and the very backroads sort of ways of creating essentially legislation. And I think that really has had some sort of profound, perhaps negative effects with athletics and things like that. But at a certain point when it comes to these really, you've acknowledged that these are really hot button issues and they're very controversial. And at a certain point I would question whether Congress is the body we want sort of putting this into the court of public opinion versus the experts at the Office of Civil Rights, if that makes sense.
Okay. So, I mean, clearly, in writing regulations, you want expertise. And that expertise is not what we always immediately associate with Congress. There are other things we immediately associate with Congress. But democracy is an effort to try to combine, or let me say, liberal constitutional democracy is an effort to try to combine the best features of two somewhat different ways of governing. One is through popular consent, and the other is through a form of expertise that tries to take a longer run. And that's what the framers tried to do by creating some insulation from public pressure through the Senate, through the President, the Electoral College, and but having all of the power come directly or indirectly from the people, as Madison put it. And I think that is the central problem. How do you create that balance of the two? And I've not been particularly impressed by the expertise of the Department of Education on these matters. It strikes me that on some really crucial matters of the basic direction of policy, it doesn't take necessarily expertise as much as it takes practical judgment and responsiveness to public views. So I'm trying to think what about this athletic question was a question of expertise? I really don't think there was much expertise involved there.
Okay, great. So my question has to do with your first point about college sports. And so it seems to me, from my interpretation, that you're basically arguing that Title IX is bad because it's pushing more women into sports at the expense of other pursuits like academia or whatever. And it seems like a very similar argument could be made for men as well, that other policies push them into sports that come at the expense of other activities as well. So I guess I'm just trying to clarify, are you arguing that Title IX is a problem because it's pushing women into an activity that is universally bad for all groups, or that there's something unique about the interaction of being a woman and being a sport that makes our current female athlete participation rates too high right now?
Sure, let me see if I can adequately respond to that. The first thing I'd say is that I don't think Title IX required any of this. I think Title IX did not require this really narrow version of what is being regulated. I think we could have had some of the beneficial effects in athletics without this tremendous narrowing. I think it would have been better if we'd taken a broader understanding of what athletics is. Do I think that this problem exists for men? Yes, and it's a lot worse. Absolutely, it's a lot worse. So I'm not saying this is a claim about women. I would actually, I'll make a broader claim, which applies to Title IX, but some other things as well, which is, this is clearly the view of a faculty member. I think universities are losing a sense of what their primary purpose is. And this is one way in which we're losing the vision of what the university is. Is women's sports the worst? Not by a long shot. I'll give you a whole list if you want. But that's why I say that in all of these areas, it's really important to keep in mind the central question, is this good for education, particularly education of women? And that is the question that in the culture war battles that have overwhelmed this area, that is the question that everyone, I think, has lost sight of.
Hi, thanks so much. My question is about a somewhat tongue-in-cheek comment you made about women being superior and men having to catch up. Back in the framework now, you remember that moment. The joke aside, would you expand on what your assumptions are about the merits of women versus men?
Mm-hmm. the merits of women versus men. There's a lot of literature that has been written on that. I'm not going to say that. What I will say, actually, I'll give personal testimony to raising a girl and raising a boy. And I think my kids were fairly typical. But what I would say is that girls obviously develop earlier. And second, tend to be more less jumpy. And clearly we know that that fewer girls suffer from hyperactivity. Now, does that mean that they are naturally inferior? Well, I don't think so, but I think it does mean that as education increasingly builds on previous education, and we know one of the difficulties with providing educational equity is that kids come to school with much different backgrounds. I mean, this is a really serious problem for trying to address the achievement gap. And that those inequalities tend to grow over time because when you have the ability to learn, you learn quicker and you go faster. So, you know, there is a developmental problem here. And I guess, you know, we need to not only think about the ways in which we provide equal educational opportunity for girls and women, but thinking about what are we doing, what could we be doing different from guys, for guys. And I'd say that this is a special problem for disadvantaged guys, especially disadvantaged guys from single-parent families who have to overcome a lot of obstacles. And that, strikes me, is the #1 issue in elementary and secondary education. I learned that mainly from my daughter.
Yeah, we've also discovered that it really would be beneficial if boys started school a year later.
Yeah.
And, I mean, I kept my youngest son out until he was a year older, and it made all the difference in the world. And a lot of people are reluctant to do that.
Hi. So just quickly circling back to the issue of whether or not all of these new regulations under Title IX are good for women's education. Do you foresee any mechanisms that the OCR can use with these recent regulations to kind of circle back to creating more opportunities for women to excel in academia, or do you think that it will just continue to be used exclusively to tackle issues of gender? Do you think that the OCR will be, well, I guess, do you foresee any specific mechanisms that the OCR can use involving the recent regulations under Title IX to circle back to creating more opportunities for women to excel in academia? Or do you think that they will just kind of continue to, and you mentioned institutional leapfrogging and kind of using those as tactics to exclusively tackle issues surrounding sports, sexual harassment, and gender identity?
So what are the prospects for some improvement? I would say the current administration, I don't expect a lot of activity, and I don't expect a lot of creative thinking, to put it mildly. I mean, actually, I will say that the person that the president nominated to be head of the Office of Civil Rights, Assistant Secretary, I think was a pretty good guy. He hasn't been confirmed yet because there's such a backlog in the Senate. But I think a lot of what they're going to be doing is to trying to somewhat improve the existing sets of regulations, especially on sexual harassment, give schools a bit more discretion and a little bit less micromanagement. But the real hard part for them is going to in some ways be more political. They have to come up with a set of guidelines that colleges are going to consider to be reasonable. If they simply say, we're going to withdraw the whole thing, do what you want, that's not going to get much traction. So it's going to take a lot of thoughtfulness and political acumen to be able to pull off something like that. Will they enter into new areas? I really doubt it. I mean, I look at track record. Basically, under Republicans, there's been basically holding patterns. Democrats, expansion of regulation. And it's hard to see at this point what OCR could, a new area they could enter that would be beneficial. And a lot of what the Department of Education is going to be dealing with over the next several years is implementation of the Every Student Succeeds Act, which is going to take a lot of time. And there, I think they can do some things, but I don't think it's going to be under civil rights.
And so kind of getting onto the flip side of the coin of that issue, so say Betsy DeVos wants to work more towards limiting the extent and the enforcement mechanisms that the OCR can use in whether related to sexual harassment or just in their general abilities, given that it's kind of got this amorphous quality to it that they can give these clarification letters. How would you foresee her kind of reining in the abilities of that organization, or just like the legislation itself?
Sure. The question, so how do I foresee the Betsy DeVos and other people at the Department of Education reining in what I've described? Well, it's already happening. One of the changes that hasn't gotten much play is a couple of changes in enforcement practices. So the Department of Education said, you remember the two things I said that the Obama administration did new in enforcement, turning every complaint into a systematic investigation, and number two, publicizing in advance. They have changed both those policies. And this is not kind of a black and white thing, because one of the criticisms the Obama administration got of its enforcement policies is that if it got a complaint, let's say a student at Dartmouth complained to OCR that she'd been the subject of sexual assault and the college hadn't responded adequately. They would say, okay, we're going to investigate everything that Dartmouth does. And by the time we finish this investigation, you will have graduated. And you will get no remedy. So there's some reason for saying that when you have a complaint by an individual, you ought to investigate that individual complaint. So they have gone to that strategy, gone back to the pre-2014 strategy, and that's going to put much less pressure on schools to follow these very elaborate guidelines. But then the question, but remember that schools don't do this simply because OCR is investigating. They're facing a lot of pressure from the media, from alumni, from students, from faculty to do a better job. And I think the question is, will they use this greater discretion to do a better job, to experiment and try things and that get us out of this sexual assault versus due process cycle? And in order to have more clear regulations from the top, I think would be extremely useful to let them see how much leeway they do have. So that's already happening, and enforcement or non-enforcement tends to be the primary mechanism. But I just add one other thing, which is in previous years when administrations didn't engage in much enforcement, people who were dissatisfied went to the courts. So I expect that's going to happen. It's not going to happen so much with sexual harassment, but certainly on transgender rights it's already happened, and I think on athletics it will happen as well.
So in your book you talk about how there was exemptions made for Boy Scouts, Girl Scouts, YMCA, Y. So keeping that in mind, you also do a little bit of a comparison between civil rights as well as women's rights. What are your thoughts on the recent occurrences within the Boy Scouts, now known as Scouts BSA, and also kind of looking at that through the lens of gender fluidity that's being more prevalent within our society, as well as sexual orientation?
Yeah, a lot of big questions there. I'll try to do so really quickly. I learned that the Boy Scouts obviously have become the Scouts, but they were not going to have gender-integrated troops. They're going to have separate troops with similar programs. So if you can either applaud or boo that. It's not going to be. You know, I was thinking when I heard this on the news last night, this is just like the NCAA. What they want to do is they want to absorb the other organization. The Girl Scouts are not very happy about this. And they might hide it under kind of gender equity, but I think it's male imperialism. But the question, one of the key issues here is how do we think about the relationship between racial discrimination and sexual discrimination? Because that's, Title IX was based on Title VI, which is about race discrimination. And obviously, most of us have decided that there's a big difference between these two. You know, there are some similarities. We do not allow black and white basketball teams. We do not have black and white bathrooms. So we don't say, well, you can have, you could have mother-daughter, or you could have, black or white dinners. So we clearly think that there are really important differences between these two. And I think that often the use of analogy which is we have made policy through analogy in these areas. And I think that's been a real problem. It's true not only in this area of civil rights, but if you look at disability rights. One of the arguments that disability rights activists made is the civil rights movement was about not making African Americans go to the back of the bus. And they say, we can't even get on the bus. And I'm sympathetic to making transportation accessible, but they're not the same thing. One is a relatively costly retrofitting of equipment. The other, going to the back of the bus, I just saw this great movie called Boycott about Montgomery. I really recommend all you see it. And it was so clear that had one purpose only, and that was to demean in the most dreadful way. So we have to make some distinctions and not, I mean, I'll put it this way, that I think a lot of other groups, and this will be provocative, have been living on the moral capital of the civil rights movement. There are some dangers of that, of diminishing the importance of taking aggressive action to combat racial discrimination. Obviously, this is something I feel very strongly about, so maybe I just ought to leave it there. Okay. Thank you.